First of all, one of the iron laws of offending and criminality is that people age out. The vast majority of people who are incarcerated and who commit crimes age out by the time they're about 30 years old. I don't dispute the fact that that looks very different with people who commit sex offenses and sexual assaults. And I agree with Mr. Hicks about that point and with a number of other people. But to simply throw around this idea that age doesn't matter, it's one of the best predictors of crime. So I think, we need to keep that in mind in terms of the vast majority of people who are committing crimes eventually age out and do desist. I'd also just like to say that some people do have places to go. We have a number of public commentary that indicates there are a number of individuals that do have housing, that do have support. And so to just take it off the table completely provides too many false assumptions that are being thrown around on behalf of justice-involved people. So I just felt like, I needed to say that in terms of some of the things that, are being said today. Thank you.
Thank you, Doctor. Any other comments?
Justice Hardesty, it's Russ Marsh.
Yes, Mr. Marsh, go ahead.
I'd like to make a motion to amend Mr. Imlay's motion to also exclude felony sex offenders. So he said nonviolent, and I would also add in people who were not convicted of felony sex offenses. And I think that would allay Mr. Hicks and a lot of other people on the Commission's concerns in that area. That's been a major topic of opposition to this. I was a prosecutor for 20 years, so I understand where Mr. Hicks is coming from. But I think that we can find some sort of middle ground. Thanks.
Thank you, Mr. Marsh. Let me first ask whether Mr. Imlay is interested in amending his motion as Mr. Marsh suggests.
I don't know if a sex offense would not fall under the violence.
This is Chris Hicks. It does fall under, Darren Imlay, it does fall under NRS 202-876, which is violent offenses.
Okay, so based on that, I would say I'm not willing to amend as it's covered in the motion and in the category.
Is there a second for Mr. Marsh's motion to amend? All right, hearing none, the motion to amend fails. Any further discussion on the motion?
This is Chairman DeRico.
Yes, sir.
I'm not sure which one of you got first.
Go ahead, Chairman.
So I believe there's a part of the motion that was brought up by Mr. Imlay. He spoke about having vulnerable persons within 18 months of parole eligibility qualify, as well as all nonviolent offenders 3 years from parole to be looked at as a review on this. And I wanted to state that I looked through what CJI has presented to us, and there is nothing with regard to any other states looking at anything that far out. They're looking at like 6 months from expiration. That's also part of the SAFER plan as well. And so in my view, this 18 months and 3 years out seems to be way off mark with what the other states are doing. I do also want to bring up for the record that as a part of AB 236, we now have, or we will have in statute effective July 1st, 2020, which is the geriatric parole statute. And why I bring this up, and I think that it's important because this is one of the points where it's been very difficult for me, and I know it's been brought up several times, that we really haven't defined, and we haven't, as agenda item 7C states, consider recommendations to the Board of Pardons Commissioners for categories of potential inmate releases. Well, in this statute that I just mentioned, and I'm going to go over some of the things that it covers because it really goes along the same lines of some of these issues that we're talking about with COVID right now. One of the parts of the statute says they have to be 65 years of age or older and have served at least a majority of the maximum term of the maximum aggregate term. It also says crimes that don't qualify: a crime of violence, a crime against a child, a sexual offense, vehicular homicide, other DUIs, has been found not to be a habitual criminal, is not serving a sentence of life imprisonment without the possibility of parole, does not pose a significant and articulable risk to public safety. So in our last session, these things here that I think that we're discussing here, or tried to, we haven't got down to narrowing this down to what it exactly should look like. It's so gray. And when we're talking about 18 months or 3 years, which isn't in line with what all these other states are doing, and then here we have at least a definition of geriatric parole that goes into effect on July 1. And then when that's considered, additional factors to consider as well are the prisoner's age, behavior while in custody, potential for violence, and the reported severity of any illness, disease, or infirmity of the prisoner, and lastly, any available alternatives for maintaining geriatric inmates or inmates who have a medical condition in traditional settings. So to me, I think, if something is being looked at to be done here and to be forwarded to the Pardons Board or the governor had already stated, according to what Dr. Salisbury had mentioned in the article, is they wanted specific recommendations. And we've done none of that. We've just kind of like, oh, well, let's throw something in here. Let's throw something in there. But as a part of AB 236, there was a lot of good and hard work that went in. And I bring up this statute because I believe that there could be a lot of correlation to particulars that could be looked at if that's something that wanted to be viewed or vetted out. But instead of the gray or the overly vague areas, that's where I have the issue here. And I think that it really should, if we're going to make recommendations, they should be specific. And lastly, the one thing, and I brought it up the last meeting, and I haven't heard it once here today again, is Marsy's Law and victim rights. That is a part of our state constitution now. Very, very important there that victims' rights be considered. And that's all I have. Thank you.
Any other?
Curtis, this is John Arascott. I have a amendment to the motion.
Okay.
To create specificity that we delete the part that says nonviolent offenses and have it as in essence shall not be considered for release if you've committed a crime pursuant to NRS Chapter 200. That would cover your murder, bodily injury, mayhem, kidnapping, sexual assault and seduction, robbery, attempts to kill, battery with intent to commit a crime, administration of drug to aid commission of a crime, duels and challenges, false imprisonment, involuntary servitude, trafficking in a person, felony assault and battery, criminal neglect of patients, abuse and neglect of children, abuse, neglect, exploitation, isolation, or abandonment of older persons and vulnerable persons, libel, harassment and stalking, peeping, tasing, pornography involving minors, dissemination of intimate images, performances of health care or surgical procedures without a license, and bullying by use of electronic communication device.
Is there a second to the motion to amend?
I'll second it. This is Emily Salisbury.
And Justice Hardy, this is Darren Emley. I would accept that amendment to my original motion.
All right. So you accept the amendment. Who made these?
It was John Arascott.
Oh, okay. Mr. Arascott had originally seconded the original motion, so I presume, Mr. Arascott, you agree with the suggested modification. to the motion?
I do. I second. I second.
And then if I could clarify then what Chairman Dorico just brought up to what I may have missed when I restated the motion about that 18 months, there with 18 months to 3 years. Was that correct in the original motion as well?
Yes.
Okay.
And that is still there. That hasn't been
Yes,
amended.
exactly. Okay.
Christine Jones Brady for the record.
Yes, Ms. Brady?
Thank you, Your Honor. Are you going to repeat the motion before having us
absolutely.
vote on it? Thank you.
Yes, absolutely. All right. Now's a good time to do that if we can, Director, and then I'll ask if there's any additional comment and we can vote on that.
Okay, so the motion that I have before the commission is a motion to send a letter to the governor to convene the Board of Pardons to consider releasing certain inmates who fit within a definition of categories provided by this commission, which include considering those who have been granted parole but not released, those who are considered vulnerable and are within 18 months to 3 years of release. And the definition of vulnerable will be the one used by the CDC, which considers those who are older and have underlying conditions, and have those who have an approved plan of reentry, and those offenders who are not convicted of crimes pursuant to Chapter 200 of the NRS, crimes against the person. Is that correct?
Right. Is that correctly stated, Mr. Imlay and Mr.
Yes,
Scott?
I'll accept that.
Great.
Okay. Any further discussion? Let's call for the motion on this. We'll take a roll.
All right. Mr. Arascata?
Yes.
Chief Carpenter?
No.
Director Daniels?
No.
Chairman Dorico?
No.
Judge Freeman?
No.
Mr. Hicks?
Nope.
Mr. Imlay?
Yes.
Ms. Brady?
I'm going to abstain based on litigation that we have regarding these issues.
Thank you. Sheriff Logan?
No.
Mr. Marsh?
Yes.
Mr. McCormick?
Yes.
Ms. Mull?
No.
Dr. Neighbors?
No.
Mr. Ponder?
No.
Dr. Salisbury?
Yes.
Mr. Story?
Yes.
Assemblywoman Wynn?
Yes.
Vice Chair Callaway?
No.
And Chair Hardesty?
Abstain for the reasons expressed before.
All right, 7 yay, 10 noes, the motion fails.
All right. I'd like to follow up on a suggestion that, or a comment that Chair Dorico made, in which he identified a statute in AB 236 that outlined certain provisions that goes into effect on July 1. And I have a suggestion that I do not believe impacts my constraint to vote on the previous motions. And that is whether or not the commission would be interested in urging the governor and the director to consider, and the Pardons Board, to consider early implementation of the geriatric statute that becomes effective on July 1, under the terms and conditions spelled out in that already enacted statute.
Justice, this is John McCormick. I would move that we encourage the governor, the director, and the Pardons Board to Consider early implementation of the geriatric parole statute as provided in AB 236.
This is Christine Jones Brady for the record. I second that.
Any discussion on that motion? Dr. Neighbor, were you trying to weigh in? I couldn't tell.
No, I'm sorry, but that sounds reasonable. The geriatric issue is certainly a big one in the question.
I don't know that commissioners have in front of them that statute, so I'm going to ask Chairman DeRico to reread the provisions related to that statute.
This is Chairman DeRico. Would you like me to read the statute in its entirety, or just highlight the main points of it that I just went through before?
I just highlight the main points, but let's begin by citing the number of the statute.
Okay, so it's NRS 213.12155, which is the geriatric parole statute effective July 1st, 2020. And to cover it, it says that in order to qualify, an individual cannot have been convicted of a crime of violence. A crime against a child is defined by NRS 179D.0357. A sexual offense is defined in NRS 179D.097. Vehicular homicide pursuant to NRS 484C.130, or a violation of NRS 484C.430, which I believe is also a DUI, felony DUI law. It also says has not been found to be a habitual criminal pursuant to NRS 207.010, is not serving a sentence of life imprisonment without the possibility of parole and has not been sentenced to death, does not pose a significant and articulable risk to public safety, and is 65 years of age or older and has served at least the majority of the maximum term or maximum aggregate term as applicable of his or her sentence. Then I further went into subsection 7, which says when determining whether to grant geriatric parole to a prisoner, the board must consider the prisoner's age, behavior while in custody, and potential for violence. Also, the reported severity of any illness, disease, or infirmity of the prisoner, and any available alternatives for maintaining geriatric inmates or inmates who have a medical condition in traditional settings.
Thank you. Any discussion on that motion?
This is Hardesty, Todd Story with the ACLU. Do we have a sense of what that total number would be from any one of the agencies participating in the meeting? Would they have that number prepared since July is rapidly approaching?
Director
Chairman
Daniels.
DeRico, I do not. It has not gone into place. And in fact, we are also working on finalizing our regs on this statute to be ready for its implementation. But as far as actual numbers, I do not have that. I just brought it up earlier because many of the things in this statute seem to correlate with some of the things that were in the CDC or presently on their website, like with regard to the ages and a lot of the things that were presented by CJI with regard to exclusions that other states were looking at, and that's why I brought it up.
If there's anyone here still from CJI, they had like the numbers when we were, I'm sorry, Rochelle Wynn speaking, when we were discussing 236, at least during session, during our work, sessions in preparation for that bill, they had specific numbers on how many people it would potentially apply to, and that was back looking at data in 2019, and I can't remember the exact number, but I want to say it was under 15.
This is Ann Carpenter for the record. I believe you're correct. I think it's even lower, just a handful that we had when we were looking at it in 2019.
I want to say it was like 6 or 7, it was really low.
This is Hardesty, Scott Freeman. Could you restate the motion, please?
I'll ask the director to do so.
Yes, so the motion before the commission at this point is to recommend to the governor and the Board of Pardons to consider the early enactment of the geriatric release provision as provided in NRS 213-12155.
So you're talking about a statute that's going to be implemented in 3 months, and the motion on the table is to enact it now?
Yes.
Do I have that correct?
Yes, in effect.
Thank you.
And Chair Hardesty, this is Chairman Dorico. Just for the record, right now, and I want to bring this up for the group. We are in a holding pattern with the office closed to the public with regard to parole hearings, and certainly there's some things that need to be done. Requirements as far as the forms to complete. There's more to the statute. Like I said, I covered the main points of the statute in there. So right now, like I said, I've been waiting on emergency declaration or for the offices to open back up to the public. So just so that you know, this is, we say enact now. So individuals have to get on an agenda as well. In order, so we could act, if it was enacted, it takes about 60 to 90 days because we already have others set on the agenda. So I just want to throw that out there right now that we are in a holding pattern until such time our offices are open up to the public.
Sure. Well, one of the points that I thought was beneficial about that framework is that it could be a framework around which the governor could operate if he chose to do so, not just reliant on the parole board and the processes in the parole board, but the governor could use that framework if he chose to do so. So it's not a strict enforcement of the provisions of that statute early. It provides that same framework if the governor were interested in using that framework to do so.
And this is Chairman Dorico again, because I thought the motion was to enact this statute early. So if it's not to enact the statute early and more for the governor to look at this same framework, something along the lines of this statute to move forward with, that's a little bit different than actually enacting, I guess, and moving the statute up. So I understand that clarification now.
Well, no, the motion was to enact it early. There's no, or to enact or utilize the statute and treat it as enacted early. But in terms of a framework, it could also be utilized in that way.
And just Hardesty, this is John McCormick, and my intent in making the motion was that to encourage them to look at implementing it early, not enacting it early. I don't think we can tell them to enact something that the legislature has set a date for when it becomes, but I think we can encourage them to, as you say, consider the implementation of the provisions or use it as a framework. So that just clarifies my intent if that was unclear.
Ms. Brady, is that acceptable to you in clarifying the motion?
Yes, Your Honor. Thank you.
All right. Any further discussion on this motion?
This is John Aristota. Could you repeat the motion, please, for me?
Okay, so right now what I have is a recommendation to the governor and the Pardons Board to consider the early implementation of the framework of geriatric release as provided in NRS 213-12155.
And that only pertains to about 6 people, is what we understand? Was that the discussion?
Correct.
I would suggest modifying the motion, amending it to apply to AB 236 in its entirety. That the governor can use his executive authority to give effect to any of the provisions in AB 236 to assist in the depopulation of our prisons.
This is Darren Emley. I would second that motion.
All right, there's an amendment to the motion. Is there any discussion on the amendment?
And then, Ms. Brady, does she?
No,
Right.
this is just an amendment.
Oh, okay.
All right, to be clear procedurally, there is a motion to amend the original motion. The amendment would expand the original motion to accelerate the provisions of AB 236 and utilize those to assist in depopulating the prison. We'll take a roll call on the amendment.
Just the amendment.
Justice Hardesty, I'm sorry. Can I make a quick comment on that?
Yes, of course. I'm sorry, Chris, I didn't see you.
I'm sorry. So AB 236, again, in this discussion we've had today about these sweeping, non-defined recommendations we're making, that was a 157-page long bill with 137 sections. It's a massive criminal justice reform omnibus bill. I don't know that this commission, in that quick order, is ready. It should be in a position to make a recommendation that we move up the effective date of AB 236. It's a dramatic shift of all of our criminal penalties, of what potential sanctions can be. In fact, the legislature gave us over a year to implement it just because of the significance of it. So I just wanted to, in case everybody in the commission isn't aware of that, I wanted you all to know that this is a extensive change to the system.
Justice, this is McCormick again. Can I ask Mr. Arascata for a little clarification? Is it the intent that the provisions in AB 236, like in Section 58 that amends the grand larceny monetary thresholds and that kind of stuff, that we recommend that the governor and the pardons board, et cetera, look at that? Or do we want to, is the intent to sort of narrow it down to those sections of AB 236 that could potentially, responsibly let some folks out of prison? I guess that's mine.
I thought I was clear on that, but no, the latter part that you stated, using the provisions of AB 236 as they apply to parole and probation, geriatric release. I don't have all the provisions up here in front of me, but it would be those provisions.
This is Chairman Dorica for the record. I think in my opinion, we're getting back to this overly broad again, where we were to a point of we kind of had things that were more succinct and without everybody knowing all the statutes contained within AB 236. I know it's an argument that's made over all the time about things being overly broad, and so I can tell you I have for discussion I have an issue with that, because then it's truly not recommendations being made that are specific recommendations that I think that this commission should make to the pardons board and to the governor.
Okay.
This is John Arascata. I would just comment, it's only overly broad if you don't trust the chief executive of our state, the pardons board, and the director of prisons.
Okay, let's call for the vote. We'll take the roll on the amendment, just the amendment.
Mr. Arascata?
Yes.
Chief Carpenter?
No.
Director Daniels?
No.
Chairman Dorico?
No.
Judge Freeman?
No.
Mr. Hicks?
No.
Mr. Imlay?
Yes.
Ms. Brady?
No.
Sheriff Logan?
No.
Mr. Marsh?
No.
Ms. Mull?
Yes.
Mr. McCormick?
Yes, I think.
Dr. Neighbors?
No.
Mr. Ponder?
No.
Dr. Salisbury?
Yes.
Mr. Story?
Yes.
Assemblywoman Wynne?
Yes.
Vice Chair Callaway?
No.
Chair Hardesty?
No.
Look at the people trying to get all the votes now that everybody has.
Everybody got what?
Who was that?
Go ahead.
Oh, anyway, so there are 12 no, 1, 2, 3, and then 7 yeses, and so the amendment to the motion fails.
All right, we'll call the motion and canvass the commission on the motion. Does anybody need to have the motion, original motion, reread?
Yes, please.
All right.
So the original motion, I believe, is the recommending to the governor and the Board of Pardons to consider the early implementation of the framework for geriatric release as provided in NRS 213-12155. Is that correct?
Yes.
Okay.
Yes.
All right. Let's see. Mr. Arascata.
Yes.
Chief Carpenter.
Yes.
Director Daniels.
Yes.
Chairman Dorico.
Yes.
Judge Freeman.
Yes.
Mr. Hicks.
Yes.
Mr. Imlay.
Yes.
Ms. Brady.
Yes.
Sheriff Logan.
Yes.
Mr. Marsh.
Yes.
Mr. McCormick.
Yes.
Ms. Mall.
Yes.
Dr. Neighbors.
Yes.
Mr. Ponder.
Yes.
Dr. Salisbury.
Yes.
Mr. Story.
Yes.
Assemblywoman Wynne.
Yes.
Vice Chair Callaway.
Yes.
Chair Hardesty.
Yes.
Unanimously, the motion passes.
All right, let's take a 10-minute break. Actually, we'll make it 15 minutes. We've been going at it quite a while. Before we get into item 8, I think we'll be able to end this meeting today if we get back here in about 15 minutes. All right, thank you. Okay, I'll call the Sentencing Commission to order. Let's do a quick roll to make sure we have a quorum. Let me do it. Yes, please.
Mr. Arascata,
Present.
Chief Carpenter,
Present.
Director Daniels,
Present.
Chairman Dorico,
Here.
Judge Freeman,
Present.
Mr. Hicks,
Present.
Mr. Imlay,
Present.
Ms. Jones, or Ms. Brady,
Present.
Sheriff Logan,
Present.
Mr. Marsh,
Present.
Mr. McCormick, Ms. Mull,
Present.
Dr. Neighbors,
Present.
Mr. Ponder, Dr. Salisbury,
Present.
Mr. Story,
Present.
Assemblywoman Wynne, Vice
Present.
Chair thank you. Vice Chair Callaway,
Present.
Chair Hardesty,
Present.
and then just to circle back, Mr. McCormick, did you join us? Or Mr. Ponder?
Yes, sorry.
Is that Mr. McCormick? Oh, great, thank you. And then
Yes,
Mr. Ponder?
sorry.
Great, thank you.
All right, item 8 on the agenda is a presentation by Director Callaway regarding the Clark County Detention Center. There's been a lot of conversation about that subject, and some issues surfaced following our last meeting regarding CCDC, so I wanted to afford Director Callaway an opportunity to comment on that and give a brief overview of where the sheriff and the chief in the 8th Judicial District are with respect to that detention facility. So thank you, Chuck, for being available to do this presentation.
Thank you, Justice Hardesty, for the opportunity. I'm going to try to be as quick as possible because I know it's been a long day. What I want to say first is my brief presentation is divided into 3 parts. First, I'm going to just briefly talk about things that we've done on the front end since late February, beginning of March, through the present to mitigate COVID-19 in our facility at CCDC. And then I'm going to talk very briefly about the order that the sheriff requested and what that resulted in. And then finally, I will give you the status as of today, as of about 2 hours ago, numbers that I have regarding the situation in the jail. So I will say this, a couple things I want to put out there before I get going is, number one, it's important to understand that when you're dealing with a facility the size of the Clark County Detention Center, just like NDOC with their facilities, things move very rapidly and there's changes that are occurring by the minute. In the last meeting that we had on April 13th, I believe it was, I receive a daily sit rep report that has the current status of what's occurring in the jail, and the information that I had on that report at the time turned out to be evolving and changing, and about an hour after the committee ended, there was new information which was released in a press release that we had a case in the jail. Then there were some questions that came up about possible previous cases of inmates in the jail. So it's important to understand that the data that I give you today is based on the report that I received today. So if I give you a certain number and we walk out of here and the news says something different that we just released, then it's because the numbers are changing as we speak. With that being understood, I want to say something really quick about transparency in regard to that. We've been putting out press releases regarding COVID-19 at Metro since late February, and as of yesterday, available on our website, there are over 21 press releases that LVMPD have put out regarding the COVID-19 situation and our agency, including the jail. In addition, the sheriff participated in a press conference back on March 25th, and during that press conference, he told the public that we had an inmate in the jail that had been released that was symptomatic and had subsequently tested positive for a strain of COVID. But it was our understanding that the COVID strain he tested positive for was not COVID-19. It's also important to understand as we look at the totality of this discussion that during a pandemic, crime does not stop. And we have some folks in our facility that are, to be quite frank with you, violent people that are committing sexual assault, people that are committing murder, killing family members, people that are committing robbery. And yes, although our overall crime numbers are down overall, we have noticed that March this year compared to March of last year, we have seen an uptick in certain categories such as aggravated assault, potentially domestic violence. We're still looking at all the facts and seeing if this is directly related to the COVID pandemic and people being quarantined in their homes, or if it's unrelated and just coincidence. But my hunch is there's a connection there. And again, as I said last meeting, it's our responsibility to adequately balance both public safety and health safety concerns. And the ultimate goal for Metro and our ultimate concern is obviously the safety of the community, the safety of our staff, and the safety of inmates in our facility. So with that being said, in late February, we recognized in the jail that things were happening around the world and that there was a potential spread of this COVID virus. We implemented in late February our infectious disease protocol in CCDC. And then on March 13th, LVMPD, our agency as a whole, set up our Emergency Operations Center, which we call the EOC, which puts out a daily sit-rep report on the current status, not only in the state, in Clark County, but also for Metro, LVMPD. As part of that, we work very closely through the EOC with all community stakeholders, the health district, the county, the city, and various other entities, fire, paramedics, and whatnot. We also initiated early in March reaching out to other jails across the country to discuss best practices, to see what they were doing to keep their inmates safe and to mitigate COVID-19. We had also participated in several webinars to learn about mitigating factors and how we can prevent the spread. Our officers in the field early on in March were advised, if at all possible, to not make misdemeanor arrests or bench warrant arrests, obviously with the exception of misdemeanor crimes that are mandatory arrest, such as DUI and domestic violence. That is still in play, obviously. Over the last couple of years, we have been making efforts to get more people out on house arrest, to participate in various programs that help reduce recidivism and get people out of the jail. And just before COVID even happened, over the last couple of years, we have, on average, reduced our jail population by around 700 inmates on average. So if an officer does make an arrest in the field for a misdemeanor crime, that has to be approved by a supervisor. When I checked the sit-rep report today, there were no bookings for misdemeanor, or I take that back, I'm sorry, we had 2 misdemeanor bookings approved. And I don't know the nature of those bookings, but I'm assuming that they are either domestic violence related or DUI. As I said, we've been making an effort to get as many people out on house arrest as we can. We currently have 935 inmates on electronic monitoring house arrest. The cap that we're able to meet for that is 950, and we'd like to meet that and get 950 folks out. So we're working on that. Obviously, there's issues with the vendor and the amount of ankle bracelets we have, and working with the courts to work those issues out. But it's something that we're working on to try to reach that 950. We have a strict medical screening in place for all inmates at the time of booking. When an officer arrives at the correction facility, they meet with a nurse and a healthcare provider from our vendor in the sally port before they ever enter the jail. The inmate is asked a series of questions regarding how they feel, where they've traveled, and also a physical screening is done of their temperature and also to see if they have any other possible symptoms before they're ever allowed into the facility. Once they're allowed into the facility, they are placed in a monitoring module for up to 72 hours to look at their condition, recheck their temperature to see if there's any symptoms they are exhibiting before they would be allowed into the general population. Everyone entering the Clark County Detention Center must wear either a surgical mask or an N95 mask. And we have 24/7 cleaning, advanced cleaning protocol of the entire jail, including the entries and the sally ports, the general booking area, the cells, the hallways, everything. We've ramped up our cleaning. For the cleaning, I know the question came up, I believe, with Director Daniels. We have a vendor that does the advanced cleaning or in-depth cleaning. We have a vendor that focuses specifically on areas where we might have had symptoms of COVID or confirmed COVID case. But we also have inmates that participate in work programs that do some cleaning, and they're also responsible for doing cleaning to a degree, personal hygiene cleaning and wiping down things, washing hands, that sort of thing within their own area, their own modules. So we also adapted social distancing guidelines for staff and inmates. And we've rotated our schedules so that there are less people out of their modules at any given time for either food or using the phones or general exercise. The exercise equipment is not available now. It's been blocked off because of concerns over the virus, but inmates are allowed to get out. They're allowed to walk, jog in place, whatever in the areas, but they have to maintain, every effort is used to maintain social distancing, just like Director Daniels said. Sometimes the inmates are cognizant of it and they're watching it themselves, and sometimes people mingle and we have to remind them and separate them. Education was provided to all inmates and staff in three formats. We posted flyers all through CCDC with the CDC recommendations. We advised them of the symptoms. We advised them of the protocol for prevention. And we also had verbal consultation with inmates about the virus and what to look for, what to let us know if they were experiencing symptoms. And then finally, there was a video that was done by command staff in the jail that was put out for both staff and inmates to view. We've issued PPE equipment to all staff and all inmates. Inmates are provided a mask that they receive, and when they get their linen changed, they receive a new mask. Currently, from the report I got yesterday, we have at least a 30-day supply of PPE equipment on hand, and we're hoping to get more supplies of that. Inmates have also been provided soap. We have not supplied them with hand sanitizer for the very same reason that the director said that they were having a concern with in the prison, folks drinking it and using it for purposes other than sanitization. So they are issued a bar of soap. They have access to running water and other hygiene tools, but not hand sanitizer at this time. We have also increased spacing between the bunks and between the phones and also restrooms, so that when inmates are using those facilities, such as the phone or the restrooms, there's spacing between them. We have quarantine of inmates. Currently, there's 137 inmates that are on quarantine that have no symptoms, but they're being quarantined based on their travel. That is based on high-risk areas where they might have traveled if they came in from another country, if they were in New York City, for example, or areas where the virus has had a heavy toll. Based on their travel, they will be quarantined for up to 14 days to make sure they're not exhibiting symptoms, and then they'll be returned to the general population. I think a big chunk of those 137 are about to be released back into general population. Also, we have two inmates, as of the numbers I got earlier, we have two inmates that are in quarantine based on symptoms. One of them, I believe they're awaiting tests on. I was told that he tested positive for pneumonia, and they believe that that's what he has, but they're doing the COVID test in addition to the pneumonia test just to verify and make sure. So they're waiting the test to come back for that. And I'll get into specific numbers in a minute of what we currently have in the jail. We put in mandatory temperature checks for staff and inmates. We have 3 thermal imaging infrared temperature readers in use in the facility. When staff comes in, their temperatures are checked. If they're above the temperature level, we have a protocol set up through our health and safety section where they can be retested if need be. They can be sent home depending on the circumstances. In some cases, if they need to be tested, that can be arranged. And we have a number of employees that are in quarantine based on possible symptoms. And again, in a minute, when I get to our daily, or what I have today for stats, I'll tell you the current stats as far as inmates that are positive and staff. We have a protocol in place, which I just said. I'm sorry, I went back at my notes. We have a protocol in place for staff who are showing symptoms, which is coordinated through our health and safety section. We have 11 negative airflow pressure cells. 9 of them are currently occupied, but only 3 of those cells are occupied with people that have symptoms that are similar to COVID-19. The other cells, I believe, are other possible infectious diseases that we see people come in with, like, for example, like tuberculosis. So on going into the release order, on April 16th, the sheriff petitioned, right after our last meeting, in fact, I believe it was it was 2 days after our last meeting, 3 days after our last meeting, the sheriff petitioned the court for an order to release certain offenders for the purpose of disease management, and the order was subsequently approved by Judge Bell. It's important to note, like I said earlier, that over the past few years, we've been working aggressively to reduce jail population overall anyway. So because we've reduced our population by over 700 inmates on average, that gives us a lot more flexibility with social distancing. But we recognize that since we had some positive cases and we had some cases with staff, that we needed to further reduce population of certain offenders in order to allow us to more safely exercise social distancing and CDC protocol. It also allows us to conserve PPE equipment. So the categories in the order that were released, inmates that were being held on probation and parole technical violations, and Chief Carpenter can correct me if I'm wrong, but I believe our numbers was about 84 people that fell into that category. We had inmates who were high risk based on CDC factors, which included being over 65 years of age, having identified pre-existing health conditions, and obviously folks that had not been arrested for a crime of violence or a crime of DUI. And then we also asked for inmates that had served 75% or more of their sentence, and then we would work backwards. So inmates that had served the most time, an inmate who had served 80% of their time would be released sooner than an inmate who had served 75% of their time, with the hope of getting as many of those folks out as we could. And then obviously there's a degree of crossover between categories. You may have someone who's spent 75% of their time and they're a nonviolent offender and they're over 65, so they fall into several of those categories. The order is in effect for 30 days. So with that, I will go into today, the numbers I have for the jail as of today. Again, if we leave this meeting, I've been in here all day locked in my office, so if we leave the meeting and the news says something, that is different than what I'm saying here, it's the nature of the game. So I apologize for that if it happens. So right now, as you know, maximum capacity in the jail is 4,189 inmates. Based on the numbers that I have from earlier today, we have a population right now of 2,484 inmates. That's about a 40%, close to a 40% vacancy rate. We have 177 inmates that have been released as a result of the order. We have the 935 inmates that are on electronic monitoring. We have 7 inmates since the beginning of this that have tested positive for COVID-19. All of them have been released from our facility except for one. We have one inmate that is in custody with COVID-19. He's in quarantine, and his crime is a crime of violence. And I believe it's an attempted murder crime. So obviously he will not be released. The others that have been released, we coordinate with the hospitals and the Department of Health and Human Services, so that, or the health department, so that there's continuity of care. So when they're released, they're not just turned out onto the street with COVID. There's a plan to get them into quarantine or get them into a hospital if need be, and there's some care after they're released. And then we are waiting one test on an inmate that, again, I talked about earlier that is exhibiting flu-like symptoms. The initial test was possibly pneumonia or flu, but we're waiting for a COVID test. We have 9 staff members who have tested positive for COVID-19. Those staff members are all on quarantine. And we have 4 members of our CO Academy that was in progress. We had 35 people in an academy for corrections. 4 corrections officers tested positive. As of the information, again, that I had this morning, there are some other tests pending of other academy recruits. The academy has been suspended, obviously for safety reasons. And currently, for the tests that we're conducting through our vendor with cooperation through the health district, we're seeing right now about a 2 to 3 day turnaround for test results when they're done within CDC. So with that, I would be happy to answer any questions you might have that I can answer.
Any questions for Director Callaway?
I do have some questions for Director Callaway.
Okay.
This is Rochelle Wynn. What are you guys doing to protect your officers? I know that there have been cases where, and I'm wondering if you've corrected it or you've been able to account for it, where someone had COVID-19, they were released to the street, and then they were later arrested again because, either recidivism or committing a new crime or whatever it is. And then the officers that go out to arrest that person are not aware that that person had tested positive for COVID-19, and now all of a sudden those officers have exposed themselves. Have you been able to do anything where you include kind of a notation in someone's scope when they're released if they have, or they have been positive?
Yes, Chuck Callaway again for the record. So when we do receive information of a confirmed positive case, usually through our partners in the health district, we are able to flag a residence, for example, where that positive case was. So if an officer is sent on a call to that address, they are aware that there was a positive case there. And then obviously we've done a lot of education with our officers. The fact of the matter is during a pandemic, our cops have to be out there and they have to be responding to calls for service. Like I said, crime doesn't stop, domestic violence doesn't stop. Our officers have to be, we don't have the luxury in law enforcement of social distancing, unfortunately. So our officers have been educated. We've done a number of videos and put out a lot of stuff. We have our whole health and safety section is working tirelessly to provide any help to officers who think they might have been exposed, where we have the ability now to get officers in for rapid testing and to get results back in a matter of a day or two. I heard yesterday, and I don't know the status of this, but they were looking at potentially allowing for officers to be tested even if they didn't have symptoms, so that they would feel comfortable going home to their families and knowing that they're not asymptomatic. We have obviously PPE equipment that is out there in the cars. Officers are encouraged to put that on. To give you an example, the other day I was over on Fourmaster Street with the sheriff, and there was a number of homeless folks over there near the courtyard, a large amount. I'd say probably 60, 70 people over there. I think they were getting in line to try to get food that was being handed out over there. And we had several officers over there keeping the peace, and they all were in full PPE equipment. And again, unfortunately, they don't have the luxury to say, I'm not going to go or I'm not going to handle this. We have a number of staff that are in quarantine. I have the numbers here somewhere in the report. I just have to dig them up for the total numbers for the whole agency. But if there's a doubt, we're encouraging, in fact, we're mandating, we're not encouraging. If we believe someone's exposed, they're going into quarantine. And we're going to monitor and make sure that they have not been exposed before they come back into the workforce.
So I know for a while that you weren't putting it in scope. So you are now officers, when they're aware that someone or a resident or a person has tested positive, so at least the officers know when they're responding to a call that they should take extra precautions?
Yeah, I shouldn't say scope. I don't know if I don't think it's being put in scope, but I believe our dispatchers have that information. And so if a call is generated at one of those locations, the dispatcher will advise the officer that that's one of the locations based on the information we've received through the health district.
I also have a question about the interaction. I know that I had received calls from like your civilian employees that work at the Clark County Detention Center that are like in intake, and they are in direct communication and weren't at one point being provided PPEs, and there was no social distancing practices in place. Is Metro working with the civilian employees that are also working within those detention centers to, do that as well?
Yeah, like I stated, we put out 3 types of education to all of our employees in CCDC, including civilian employees. It was in written form, it was posted, it was done in a video, and it was also done verbally by supervisors that went around and talked to their people. And in addition, on our website, we have put out protocols on lvmpd.com for our officers to review. We also PPE equipment, from what I was told yesterday, all of our staff and inmates in CCDC have access to PPE equipment. So I'm not going to sit here and tell you that early on when this thing first happened that maybe somebody was in an area where social distancing was not possible at that time, but I believe that we have taken every step at this point to ensure that that's happening.
Any additional questions from members of the commission?
Yes, Chair Hardesty, Todd Story with the ACLU. Chuck, you had mentioned crime rates. You said that some were going up. I've seen some reports that say that overall crime has gone down since the stay-at-home orders were initiated. Could you clarify that for us, please?
Sure. So you're right in respect that overall, compared to last year, year to date, our crime is down, with the exception of aggravated assaults. I believe we're about 200 higher this year with aggravated assaults than we were last year. However, we have had some specific area commands that have, during the month of March, seen a higher number of aggravated assaults and some firearms-related crimes compared to that same geographical area last year during the same time period, if that answers your question. But yes, according to the year-to-date numbers, they are still below, in most regard, or even to what they were last year, with the exception of aggravated assault.
Got it. Thank you.
Any other questions for Director Callaway?
Yes, this is John Arascata. I have one. Director Callaway, what's the recidivist rate of those that have been released from the jail under the depopulation order?
Chuck Callaway again for the record. That's a great question. Because this order went into effect April 16th, I am not sure if anyone that was released on this order is back in, but that is a fantastic question, and I will reach out after this meeting and find out if we're tracking that, because if we're not, we definitely should be.
Okay, and also the homelessness rate and the unemployment rate, please.
Okay, I'll find those out as well. Those would be screening questions when the inmate's screened when they come in. So I'll see if again, if we're collecting that data in regards to what's occurring during this pandemic, and I'll provide that back to the commission.
I appreciate it. Thank you.
Any other questions for Director Callaway? All right, seeing and hearing none, let's turn to item 9 on the agenda and get a quick update from Ms. Straight on the implementation of AB 236 plan. And this would be under item 9 of your tab 9 of your materials.
Yes, hi. For the record, this is Abigail Street. I know it's been a long day, so I'll try to be quick. You received another handout from us. It should be in your packet. It's an updated implementation plan for AB 236. This should look familiar. We distributed an older version of this at the previous meeting in February. This has since been updated to reflect the progress Nevada has made towards implementation of AB 236. One thing I want to note is that this is just the work that we are aware of. We can offer technical assistance to any agency that is involved in implementing AB 236. And some agencies have requested more assistance than others, so it's possible that there may be more going on than we are aware of. So as we are getting closer to July 1, I think we talked about in February that one important takeaway from the research on implementation is that implementation of anything doesn't happen overnight. Rather, it happens in stages. Lots of work has happened so far across many different agencies in Nevada to implement AB 236. And as we approach the effective date, there are still things to do, but that is to be expected. It's also to be expected that sometimes things happen that throw a wrench in implementation. And agencies have been dealing with that right now as they juggle implementing AB 236 with responding to COVID-19. This may alter, delay, or maybe even expedite some activities. So it's important to analyze what needs to be done, what still needs to be done, but I think it's also important to recognize all the work that has been done so far. I'm not going to go through the entire plan with you right now, but I wanted to highlight some important points. First, with regards to Department of Corrections, NDOC has continued to work hard over the past few months to move forward with many of the initiatives that they had already begun prior to the passage of AB 236. They've been successful in training all existing staff in core correctional practices, and we are working with them on a plan to continue to train staff in the skills. NDOC has also been working closely with various community partners to initiate training events in areas such as risk and needs assessment, case planning, trauma-informed care, and responding to behavioral health needs. Additionally, NDOC has rolled out the NRAS and is in the process of planning for the first validation study of the tool, which will be completed through the University of Cincinnati. Next, the Parole Board has revised their internal handbook to fit with AB 236, which is a pretty big undertaking. And in addition, they've been working closely with NDOC and NPP and other partners to ensure that all are on the same page. This collaboration is an essential part of effective implementation for everybody, and I'm going to speak a little bit more about that in a minute. But first, I also wanted to highlight the Division of Parole and Probation. They created working groups to develop policies, forms, and trainings for each of the areas of AB 236 that impact the division the most. These working groups were made up of staff from different regions, and each group has now created new policies and forms that fit with AB 236. And those are, I believe, under the review by senior leadership currently. NPP also has a training group that was in charge of ensuring officers are trained on those new policies, as well as the topics required by AB 236 that officers be trained in. Originally, the plan was that the training team would combine educational materials from each working group and roll those out during in-person sessions, training sessions this spring and summer. But obviously, COVID-19 has complicated those plans. As the training team cannot gather people together for these trainings now, they're developing an alternative plan to train officers, involving using a series of webinars. The training team is working on the logistics of that plan now, and we're working with them to look for ways to make sure webinars are interactive and responsive to different learning styles. So it's a challenge, but one the training team has been working really hard on. Finally, as I alluded to earlier, I think something that is important, but that may not be immediately evident from looking at this plan is how much interagency collaboration has been taking place. I think maintaining open communication between implementing agencies is super important. It helps us all be open to new ideas and adapt together when roadblocks like COVID-19 or others come up. However, collaboration can also be really hard. Sometimes agencies aren't used to working together or could even have bad blood from past negative experiences. So this is something we often see states struggle with. So I'm really excited that that hasn't been the case in Nevada. In particular, many sections of AB 236 impact NDOC, NPP, and the parole board and require them to get on the same page. And we've really seen NDOC, NPP, and the parole board embrace this spirit and have held several joint meetings with teams in both the North and the South to discuss the work that each agency is doing on implementation and identifying how the changes each is making would impact the others, and talks through ways to collaborate and help each other. I think this spirit is especially important to continue throughout the many stages of implementation. So even as we continue on, both the day-to-day collaboration between agencies and also the more formal means of collaboration like the Sentencing Commission. As implementation continues, other roadblocks or unforeseen issues will likely arise, and so having prearranged avenues of communication make it easier to continue to check in on those and to work out solutions together. That's what I really wanted to highlight from this. You all have the full plan, so feel free to either now or later ask questions if you have them, and that's what I wanted to highlight.
Thank you very much. Are there any questions for Ms. Straight on her update on the implementation plans?
This is Emily Salisbury. I just have a quick question. So can you clarify something for me just in terms of the alternatives to incarceration provision of AB 236? So is that firm and done, or is there going to be additional exploration about what other alternatives might be suggested?
I'm not sure I understand your question. Can you clarify?
Yeah, so the alternative to incarceration sort of discussion on what page am I on? I'm on 150 of the complete PDF that I've got here. I recall there being discussion about expanding like specialty courts and alternatives to incarceration. Can you just clarify for me if that is finalized, if this body will be discussing additional potential alternatives to incarceration, or is that set in stone now because of AB 236?
So you're asking, will there be further clarification or further expansion of what was passed in AB 236?
Correct. I didn't know if there was going to be any more additional discussion about other alternatives. I realize that there are things that have been passed, right, obviously, because of AB 236. So yeah, I just didn't know if there was additional discussion on that or if that's done.
That's a great question. Not that I'm aware of, but that doesn't mean that there haven't been others or that there can't be others.
The reason I bring it up is because I know I'm aware of some other alternatives to incarceration, specifically around sentencing, parenting sentencing alternatives that have shown to be effective in Washington and Oregon State. But I, again, just wasn't quite honestly sure if and when those suggestions could be made.
Can I just step in for a second, Justice Hardesty?
Yes.
I know that that's something that obviously we can address here at the Sentencing Commission, but I know in the ACAJ, that's one of the topics that we're looking at exploring is the use and expansion or inclusion of more of these alternative programs such as specialty courts. And I know I'm doing it as a part of my own personal BDRs too. So there are opportunities. So I can reach out to you, Emily, and we can talk more about it offline.
Thank you so much.
I don't think anything's off the table for the Sentencing Commission to agendize, but I worry about prioritizing what we have to do in this commission alone. And as I had expressed early on when we convened, I think our major goal is to take the steps that we're required to take under AB 236, get the reports as best as we can, get those done. As you heard from the director, our policy BDR, unless extended, expires May 1st. So that would require a full vetting of alternative legislation for the commission to recommend. And I just don't see that that's practical within the time frame we have. So if the advisory commission has some space on their agenda to look at additional alternatives, great, but I think our plate's pretty full with respect to the responsibilities that we have this calendar year.
That makes sense. I understand that, Chair Hardesty. I'll get in touch with Assemblywoman Nguyen. Thank you.
Any other questions for Ms. Straight? I wanted to also mention, and you probably saw it in your materials, the circulation of a practitioner guide to AB 236. I think it's really well done. Barbara, because of the interest of time, I'm going to move on other than noting it. But in particular, I wanted to call it to the attention of all of the lawyers on the commission, because I think that it is a useful tool in working with your offices in trying to facilitate their understanding and application and use of the changes in AB 236. And in particular, Mr. Hicks, if you haven't already done so, you probably have, but I would ask if you could have Ms. Noble review it, and in the context of any modifications to the requests that your office has made, look at the work in this practitioner guide to see whether it gives you a head start, let's put it that way, on some of the things that, some of the activities that you had in mind with respect to the budget request you made for the grant.
Will do.
All right. There is a discussion about future topics. I think our agenda is pretty full, but I just say if people have an interest in pursuing topics or particular topics, if you could just send those to the executive director, and I'll review them with her as we build our budgets going forward. Our next meeting is July 29th. I'd like now to turn to the second phase of public comment. In that regard, I believe Director Gonzalez has sent to you 3 emails. The first conveyed public comments numbered 17 through 41. The second conveyed public comment 42 through 47. And the third conveyed public comment 48 through 52. Is that all of the public comment we have?
Correct.
All right. So if you would, as we did this morning, Director, flash on the screen who submitted the public comment 17 through 41, and leave that up there for a little bit while the commissioners are looking at that public comment, and then we'll switch over to the public comment that's provided for 42 through 47 and then 48 through 52. So commissioners, if you would take a look at the 3 emails and the public comments submitted, and then in a few minutes I'll check back with you to see if people need additional time to study the public comment that's been provided.
Director Gonzalez,
Yes.
the screen is away from your camera when you're not talking. If some of the other commission members could put themselves on mute.
I'm going to hold up public comment 17 through 42 again. Go through those. This is 17 through, let's just 17 and 18. Nineteen through 26. Twenty-seven through 34. 35 through 42.
Do any of the commissioners need additional time to complete their review of the public comment 17 through 52? Has everybody reviewed the public comment 17 through 52? Please acknowledge with a yes.
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 Has anyone
Yes.
has anyone not been able to review the public comment 17 through 52? All right, thank you. I thank you all for your hard work today and the deliberations that we've participated in. Be safe, and the meeting will stand adjourned. Thank you all for your time.
Thank you.
Thank you.
Thank you.